mini MCLE La-LAW-palooza. We have an exciting MCLE on patent developments in 2021. Today we are joined by John Laneham and Janet Kim, who are IP litigators with Morrison and Foerster's San Diego office. We are also joined by Denise Hickey, the Assistant General Counsel with Bristol Myers and Cribb. Together, they will be guiding us through an exciting 60-minute CLE on emerging issues and trends to keep an eye on in patent law that warrant the attention of in-house counsel. Welcome, John, Janet, and Denise, and thank you so much for guiding us through this next hour and providing your wisdom to us.
Hello and good morning, everybody. We are going to be covering three general topics today. First, we are going to walk you through some statistical trends that we've been seeing in patent law at the higher courts. And then we are going to go through some of the hot issues that are emerging in patent law right now. In particular, Section 101 patent eligibility continues to be one of the most important issues in all of patent law, as well as some emerging venue issues that we are seeing, and issues concerning the constitutionality of the PTAB and the powers of the PTAB in reviewing granted patents. Time permitting, we will cover some emerging damages trends at the end of the presentation that are emerging panel split issues within the federal circuit that warrant particular attention for anybody involved in patent litigation. And throughout the presentation, we will have the benefit of input from Denise, who handles all manner of intellectual property issues for Bristol Myers Squibb. And she will be giving us the in-house counsel perspective and her own commentary on some of these developing issues. So without further ado, at the Supreme Court, the last couple of years have been relatively quiet with patent decisions. We saw in the mid-2010s one of the historically busiest periods that the Supreme Court has ever had in making patent decisions. And many of those decisions the court was making at that time concerned big picture issues like what kinds of inventions are eligible for patenting, what it takes to infringe a patent indirectly, and what to do with misconduct either from infringers or misconduct during litigation. The last few years, the Supreme Court has primarily been focusing on narrower issues, and in particular, administrative procedure issues that relate to the Patent Trial and Appeal Board, which Janet will be getting into later on in the presentation. But there are some signs that 2021 is going to be a hotter year at the Supreme Court for IP issues. The Supreme Court has already granted cert for two patent cases. The first being the issue of assignor estoppel. So essentially the equitable doctrine of if you assign your rights in a patented invention, can you later challenge the validity of that invention if you become involved in litigation? And the second being the constitutionality of the judge appointment and retention for the PTAB. And Janet will be discussing that case, US v. Arthrex in particular, later on. The Supreme Court for 2021 has also granted cert in a major copyright case, Google v. Oracle. And in that case, it will be deciding whether copyright protection extends to software interfaces and what the fair use of such an interface might be. On top of those three cases, the patent bar seems to be betting that the Supreme Court will be taking up cert in at least one additional patent case this year, American Axle, which we'll discuss in specificity in the Section 101 portion of this presentation. But with those three and potentially four cases, this has the likelihood of being one of the busiest Supreme Court dockets for patent issues in years. Meanwhile, a level down from the Supreme Court at the Federal Circuit, we continue to see the same trend lines that we've seen since 2017 or so. And in the 2013-2014 period, we see a huge uptake in cases that are originating in the Patent Trial and Appeal Board, That's coming out of that board being started with the American Invents Act in late 2012 or so, and the 12-month period that the PTAB had to resolve cases under the AIA. So we see an immediate increase in PTAB cases to the point where they've now actually overtaken district court litigation in terms of appeals to the federal circuit. That continued through 2020, still on the order of something of 60% of all PTAB decisions are appealed to the federal circuit at this point. Though interestingly, the PTAB success rate for appeals is actually even lower than district court. On average, the federal circuit affirms district courts in 70 or 75% of the cases that are appealed. Despite the higher number of PTAB appeals, the success rate is even lower there. It's as of the end of last year, it was on the order of 85% of appeals were affirmed by the federal circuit. And to put in a plug for our federal circuitry blog here, you have the link in the presentation, but if you'd like to see further detail on statistical breakdowns of federal circuit decisions, even to the level of the activity of particular judges on the federal circuit, we have a great data-driven blog at that link. As it has been for the last couple of years now, patent eligibility continues to be likely the leading issue in all of patent law. And for those of you who may be unfamiliar with the patent eligibility issue, the Patent Act provides that only certain ideas are eligible for patent grants. The statute refers to processes, machines, manufacturers, or compositions. And note that the statutory language itself says whoever invents or discovers. And that or discovers language is something that we'll circle back to in a couple of minutes, but it is becoming an important issue for which direction the Supreme Court and the Federal Circuit is headed with this law. Now, reading that statutory language, courts have read a exclusion rather than a scope of grant into the eligibility question. And the judicial doctrine is that laws of nature, natural phenomena, and abstract ideas are not eligible for patenting. And under the Supreme Court's 2014 Alice case, the district courts are instructed to perform a two-step test for eligibility. The first is district courts ask, is the patent directed to one of those ineligible concepts, being laws of nature, natural phenomena, and abstract ideas? And second, if so, is there some kind of inventive concept in the patented invention that transcends what would otherwise be an ineligible idea? Now, if that sounds like it is probably a difficult test to apply in practice, that's because it is. And the Federal Circuit case law following this series of Supreme Court decisions from the 2014-2015 timeframe is mixed at best. And this slide has some examples of types of inventions that have been subjected to eligibility challenges. And at the top here, we have mechanical things and devices. Those historically have been patent eligible, and in general, they are still being upheld as patent eligible inventions. But as we make our way down this list to method of medical treatment, improvements to computers, for example, those more often than not are being found eligible by courts, but there are now starting to be a lot of mixed decisions on those issues. And then by the bottom of this list, we are down into ideas like how to streamline businesses, how to organize human activity, identifying things in nature like scientific principles. And those are at very high risk of eligibility challenge at this state in the law right now. But at the end of the day, there is very little clear guidance right now on how to solve the eligibility problem. And it's entirely likely that two judges or two panels looking at the same claims could reasonably reach different conclusions about eligibility. And in fact, we are seeing that pretty frequently at the Federal Circuit right now, as we'll cover in just a minute. Over the last couple of years at the Federal Circuit, there have been two cases that the patent bar thought would bring the Section 101 eligibility issue back to the Supreme Court for further clarity. The first case is Athena Diagnostics v. Mayo. And that case was about a method for diagnosing disorders based on detecting particular antibodies. And the district court in that case found those claims were directed to an ineligible law of nature. And the patent owner had argued that the claims actually provided concrete steps and a new laboratory technique rather than just discovering laws of nature. The Federal Circuit panel that heard the case disagreed with the patent owner and found that the patent highlighted the discovery of a natural correlation between the antibody and the disorder, which was an ineligible law of nature, and that there was not enough content in the claims to transcend that ineligible concept. And now remember, a couple of slides ago, we had looked at the statutory language, which includes discovery in the scope of eligible content. But in Athena, as well as some other Federal Circuit case law, we have seen this characterization of moving away from pure discovery as being patent eligible, but rather discovery or invention plus something further. And that something further is where things are getting really messy right now under Federal Circuit precedent. And Judge Newman submitted a lengthy dissent in the Athena case, and she pointed out that the invention enabled diagnoses that had been impossible before, and therefore must have contributed something more than just a discovery of a natural law, and made the observation that striking diagnostic patents like this is very likely to have major negative consequences for the biomedical field and the pharmaceutical field. And maybe unsurprisingly, the Athena decision had attracted a lot of attention and resulted in the submission of a number of amicus briefs for the rehearing as well as the cert petition. And this is the caption from the denial of the petition for rehearing, which is maybe the longest denial of rehearing that the Federal Circuit has ever issued. Has not only the denial it sent with this breakdown of all of the judges and the various positions they were taking on the petition, but then a number of concurrences and denials where the authors of the original panel opinion and dissent and others on the Federal Circuit were joining to either defend the panel's reasoning or dissenting and saying why that issue needed to be reexamined. And given this huge ideological split between members of the Federal Circuit, Athena was an odds-on favorite at the time for the Supreme Court to take up the eligibility issue. And we even had, with the Supreme Court cert petitions, the Solicitor General joining in to say, either in this case or another case, the Supreme Court needs to weigh in and provide further guidance on eligibility. Nonetheless, the Supreme Court declined certiorari last year. So we have next up, the next great hope for Supreme Court clarity on this issue is the American Axle case. And as of today, this is currently pending the court's decision on certiorari. There were a round of amicus briefs submitted earlier this month. And I think we are likely going to see a cert decision fairly soon now. So we'll know whether or not we're going to get the clarity through this case or not. And the American Axle case concerned a patent with a method for making a drive shaft to minimize vibration. And it did this by using a particular frequency tuning. The Federal Circuit decided that this was just directed to a natural law called Hooke's Law and didn't have anything further in the patent to get beyond the discovery of a natural law. American Axle petitioned for rehearing, and the Federal Circuit granted a panel rehearing and issued a modified opinion, again stating that the claim simply invokes this Hooke's Law, this natural law, and adds nothing more, and did not recite the techniques needed to achieve the claimed result. So it sounds like we now have enablement or written description requirements creeping into what might otherwise be an eligibility case law issue. And Judge Moore, who dissented from the original panel decision, again dissents here, with this quote, the majority's nothing more test, like the great American work, The Raven, from which it is surely borrowing, will, as in the poem, lead to insanity. And we see again from this wing of the Federal Circuit, this concern that Section 101 is starting to creep to cover all of patent law and is fundamentally going to change the scope of patentability analyses by bringing in these other kind of doctrinal considerations like obviousness or written description. And again, the Federal Circuit declines to take up rehearing en banc for this case, but it has a 6-6 split. And Judge Moore, again, feeling very passionate about this, writes that the Federal Circuit is at a loss as to how to uniformly apply Section 101. And what we have here is worse than a circuit split. It is a court bitterly divided. So there clearly, again, is a calling for the Supreme Court to come in and clarify some of the questions that the Federal Circuit has been dealing with differently, depending on which panel you get. So hopefully we will see movements from the Supreme Court on this soon to understand whether we're getting the clarity. And the particular questions the Supreme Court would be addressing in that appeal are the appropriate standard for directed to under the first step of the eligibility analysis, and whether eligibility is a question of law or fact, which in a number of Federal Circuit decisions has had a significant impact on when courts are able to take on the eligibility question and whether they can do so in connection with either summary judgment or a motion to dismiss, or whether the eligibility question is something that the jury ultimately has to decide. Now, we have here a few polls to get folks thinking about the eligibility analysis. So we don't need to do any formal Zoom polling or anything like that, but think about whether, based on the discussion we've just had of Section 101 case law, you think that the inventions described in these slides would be eligible for patenting. So the first is a method for sending data between devices with user identification and authentication, which purports to make data capture devices simpler and more efficient. So we have here essentially a device-to-device communication and movement of data, and an assertion that it is somehow making those devices work better. Federal Circuit considers this claim and says this claim is eligible for patenting. Even though the idea of capturing and transmitting the data is abstract, step 2 saves this claim because there is a plausibly inventive concept. And in doing this, the Federal Circuit looks to the specification of the patent and says the specification asserts that this is an improvement as to these devices. And because this was early on in the litigation, the court had to take the specification's assertions as true as a matter of fact. And like we had just discussed, there is a question now for the Supreme Court to resolve on whether this is a matter of fact or whether this is a matter of law. But this panel treated it as a matter of fact and said, based on those allegations in the specification, this claim has to be treated as eligible, at least for the time being in that case. The second situation is a barrier device that wirelessly communicates status conditions to a controller, which purports to allow for communication of lighting conditions or obstacles. So again, here, device-to-device communication, and the assertion that the device or that the claimed invention made those devices operate better by allowing them to detect certain things that they needed to detect. Here, ineligible. Again, capturing and transmitting data is abstract, but it is not saved by step 2 Alice in the situation. The inventor had pointed to the wireless transmission as an inventive concept, but wireless transmission itself was abstract. So the Federal Circuit thought that there was a circular argument here in the spec and from the inventor, that the inventor was trying to say that the improvement was the ineligible concept itself, which this particular panel of the Federal Circuit said was not good enough and rejected the claim. And our final poll here is a method of preparing fetal and maternal DNA for analyzing chromosomal aberrations. Here, the Federal Circuit says eligible, and it doesn't even get to step one. It says, it does not get to step two. It says at step one, this is not an abstract idea. This is a claim that's directed to a human engineered method of preparation and not a natural phenomenon, even though it had to do with the operation of DNA and what you could tell from DNA that was being detected in nature. There's a dissent here, which is directed to the surprising discovery of a natural phenomenon, did not make use of new or useful techniques. So again, compare the tension here with Illumina to the Athena case, where we saw a rejection of similar kind of biological related issues. So where does this leave us with the mix of decisions and the question of whether or not the Supreme Court is going to do anything to clarify these issues this year? For entities that are becoming involved in litigation or are already involved in litigation, there is a significant change to strategy on the timing of eligibility challenges. And this is the issue of whether these are questions of law or fact. And if they are considered questions of fact, more often than not, they're not going to be able to be resolved at the pleading stage. So they're going to be resolved sometime later in the litigation. Whereas traditionally in the time period immediately following the Supreme Court decisions in 2015, 2016, these were often motion for judgment on the pleadings or motion to dismiss issues. We now have district court judges who are feeling less and less comfortable with resolving eligibility challenges early in cases. Second, for innovators who are looking at this and trying to decide what to do with their patents, there is, I think, now increasing consideration of whether to seek patents in the first place or whether to simply not disclose that technology and try to keep it as either confidential or trade secret. Trade secrets, of course, don't give you the right to exclude others from discovering that same invention and practicing it. And in the biomedical field in particular, trade secrets are not always great for things that can be reverse engineered. But we are seeing, I think, a disincentive to disclose innovations, at least until this 101 case law gets clarified. Third, we are seeing a real focus on quality draftsmanship of specifications and claims, particularly so long as courts are obligated to take specifications, characterizations of inventions and what those inventions are adding to the art as true as a matter of fact for litigation purposes. Draftsmanship is very important, and careful draftsmanship with a deliberate focus on 101 issues is something that folks who are deciding to pursue patents should be very careful that they're working with their counsel on. And finally, there has been a question on whether or not the weakened state of 101 law is going to lead to non-practicing entities reasserting claims that perhaps earlier they felt uncomfortable about. That is, I think, a legitimate concern, but it's something that I'm not sure is actually being borne out in the statistics. NPE litigation over the last couple of years has increased only slightly, and overall district court litigation has trended downward until 2020 when it ticked slightly back up. So it remains to be seen, and perhaps any action in the American Axle case will push further NPE litigation or maybe suppress NPE litigation. But personally, I don't think that that's something that has really been a significant issue so far. So I'll turn it over to Denise now for her commentary and her insights on where 101 stands right now.
Thanks, John. Actually, I'll ask you to go back to your previous slide because it's a great summary of the practical consequences of 101. You know, I think from a high-level perspective as in-house counsel, our issue is the uncertainty around all of these matters, right? So for those of us that work for companies that are dependent upon innovation and investment in innovation and being able to protect that investment, the uncertainties around patent eligibility and even the trends that we're seeing, like the authority of the PTAB are critical to us. They affect our decision making on a nearly daily basis. It's very difficult to draft your patent applications to protect yourself against laws that are uncertain and unknown, and that won't even be an issue for another 10 years or so. It's very difficult to justify investing on discovering natural products that might cure disease when you're not sure that you're going to be able to protect them. And to your point, John, you mentioned the increasing importance of trade secrets and trying to maintain your innovations in confidence to maximize their value, and how difficult that is in the biopharmaceutical industry, where we are obligated, and rightfully so, to disclose that information to agencies in order to get approval of our products. And so, we're really between a rock and a hard place, and it will be interesting to see, not only within the US, but abroad, the issues around patentability and the role of patents in stimulating innovative economies is a heightened concern. And we'll see what happens as we move forward. So having learned a little bit about the role of patent eligibility in creating this realm of uncertainty for innovative companies, let's hear from Janet on trends in the PTAB and the issues around their ability to even operate. So thank you, Janet.
Thanks, Denise. Yep, so I'll be moving on to some developments in PTAB practice over the past year. If we go to the next slide, here we're looking at institution rates, which is always interesting to look at. So once a petition has been brought either for IPR or PGR or CBMs, this will show you the stat of when the PTAB is going to be instituting a trial on that petition. So if you look here at, we have rates going back to 2016, but for the last fiscal year ending in September 2020, you can see that we have PTAB institution rates that are trending lower. So by patent, we have low 60s. And then by petition, we have 56% institution rate. And this is definitely a trend lower from recent years. We don't have the stats shown here, but back in 2013, it was high as 87% for petition. So that was definitely alarming for patent owners to see. So some of the reasons behind this trend, some suggest that patent owners, given the prolific post-grant proceeding practice, patent owners are just being more selective in the patents they're asserting. They're choosing higher quality patents to assert in litigation, knowing that a big strategy now is to enter PTAB practice after a patent has been asserted. Another reason for this could be that the PTAB has been engaging in more discretionary denials to deny institution. So, whether or not the PTAB decides that an issue was already considered on prosecution, or under FinTIB, we have a recent decision that was designated precedential where the board can decide that an otherwise meritorious claim might not be eligible for institution because of the advanced stage of a co-pending litigation. So this definitely comes out in fruition when you have dueling litigation in the district courts and before the PTAB. So something to take away just from these stats here is that because of this decreasing trend, if you are a petitioner seeking to stay a co-pending litigation, it's important to look at these recent rates because you might have cases from prior petitioners seeking to stay earlier on that cited to higher rates in the high 80s, like I mentioned, from years past, and those rates really aren't relevant anymore. So moving to the next slide, we can look at some of the outcomes of recent years. So despite COVID, PTAB stayed busy. They were one of the first forums to switch over to remote only. So they, in March of 2020, they were already moving to virtual hearings. They held over 1,000 hearings last year. So they continued their rate of final written decisions. In fiscal year 2020, we had 28% of challenged claims found unpatentable, and 53% of those were instituted claims found unpatentable. Comparing that to the year prior, we had an increase from a 25% rate of challenge claims and 47 rate of instituted claims that were found unpatentable the year prior. So one of the reasons for the declining institution rate and improving success rate for petitions that do get instituted could be that the board is becoming better at deciding at the outset at the institution stage whether a petition will ultimately become successful. So those are the two rates in tandem, looking at them together. So the bottom line is that instituted claims are still being found unpatentable largely. So for patent owners, this means that resisting institution is going to be one of the strongest ways to protect against challenge claims. And given this discretionary denial practice we just mentioned, for patent owners, this is going to mean trying to assert your patent in a forum with a quicker schedule, these rocket docket patent forum where your case is going to be an advanced stage before a petitioner can get their IPR on file. And for petitioners on the flip side, this might mean wanting to request, knowing that this request for discretionary denial may come up, it may mean trying to assert an IPR over broader claims than knowing what will be asserted later on in litigation, trying to preempt that to get your petition on file. Because the PTAB decides institution on a statutory schedule, you can kind of map out the steps to know the timing of when the institution decision will be in place. So moving on to the next slide. So this, what John highlighted, this case that's been closely followed. This is the Arthrex case. So starting at the federal circuit stage back in October of 2019, the federal circuit decided that the statutory scheme for appointing the PTAB judges, those are the administrative patent judges, or APJs, was in violation of the Constitution under the Appointments Clause. So if you remember back to con law, if you have a principal officer, that officer needs to be nominated by the president and confirmed by the Senate. And that same standard does not apply to inferior officers. So the federal circuit looked at the APJs and decided that they were in fact principal officers. And because they didn't go through the appointments designation that was required under the Constitution, they found the scheme was unconstitutional. And rather than deeming every decision by an APJ invalid, the federal circuit decided to put in place a remedy that would keep the scheme together, but would render it constitutional. So they severed a portion of the Patent Act that restricted removal of the APJs, and instead permitted the PTO director to remove APJs without cause. So removal with or without cause is one of the factors considered in deciding whether an officer is principal versus inferior. So in order to permit future designated APJs as constitutional, the federal circuit put in place this remedy. So the immediate impact of the decision was that the federal circuit vacated nearly 100 PTAB decisions where this appointments clause appeal, and then remanded again by the newly designated APJ panels. In 2020, the PTAB ordered that all of those cases be held in abeyance pending the Supreme Court taking this issue up to either affirm or clarify what the appropriate remedy should be for the unconstitutionality of the APJs. So if we go to the next slide, the Supreme Court did take cert on this issue in, So first, whether or not the federal circuit was correct in its designation of the officers under existing jurisprudence. And the other question was whether or not the federal circuit's proposed remedy to remove the removal protections for the APJs, if that was the appropriate way to address the unconstitutionality of the appointments of the APJs. So if we go to the next slide, we recently had oral arguments held on this case earlier this month in March. The questioning largely focused on whether or not the APJs were in fact inferior officers and where the line between those two designations should be drawn. There was less focus on the severance remedy, and there was a lot of focus on the director of the PTO's power to review decisions rendered by the PTAB judges. So this is being closely followed. Of course, I just mentioned that 100 cases are held in the bounds of this decision. We're expecting a decision in June of 2021. And the interesting thing here is there's not really a binary outcome based on the Supreme Court's decision. So because there's two aspects of this, we have the threshold question of whether the designation of the officers was correct, but we also have the question of what the appropriate remedy is. So taking in turn, the least consequential to most consequential possible outcomes we have, the Supreme Court could overturn the Federal Circuit's decision entirely and say, you were actually incorrect about the unconstitutionality of the APJs. And in fact, they are inferior officers that are appropriately nominated. So if that was the case, then we return to status quo. The 100 cases are not in question and everyone moves on. The next possible outcome, of course, is if the Supreme Court affirms the Federal Circuit's decision, then we know the impacted scope of cases. It's those 100 or so that are currently stayed, and those would have to be reheard before a new panel of APJs. And the next possibility is if the Supreme Court affirms the designation of the officers, but then decides the remedy was incorrect. So we mentioned that the Federal Circuit decided that it would change one of the removal powers of the director of the PTO in order to be able to remove APJs without cause. So if the Supreme Court finds that that remedy was inappropriate, there's a whole number of different remedies it could put in place. And this brings, a question into what the scope of affected cases would be in that case. And then lastly, on the spectrum of chaos would be if the Supreme Court finds that the officers were correctly designated as principal, but finds that there's no constitutional cure for that and leaves it open to Congress to correct this statutory framework. So of course, this would put into question all of the decisions made by any APJ panel and future cases filed before the PTAB. So we're closely watching that one and expecting a decision in June 2021.
That's great. Thank you, Janet. It's very interesting how the PTAB has, the growing pains that the PTAB has had to go through since its inception a few years ago. And I think that it's also been interesting to see, while I realize this was not something that you touched on specifically, but interesting to see how different industries utilize PTAB procedures to defensively or offensively for their portfolios and their products. One of the things that is a big issue for companies is deciding whether to roll the dice before the PTAB, right? So whether or not to take a chance on all this uncertainty and go ahead and file an IPR against a third-party patent, knowing that it's just really uncertain whether it'll be instituted at all, particularly now that the bar has been arguably slightly raised for institution. And then what the ramifications are if it isn't instituted or if it is instituted. So if it isn't instituted, what the ramifications might be later when it's asserted, the patent's asserted against you, and you need to decide how to defend against that. And if the IPR is instituted, then what's the likely outcome? And just is it even going to be valid at this point? I suppose we'll know that answer a little bit sooner rather than later. But this segues very nicely into the next topic, the next hot issue topic, which is venue. So in addition to choosing whether or not you want to go to the PTAB or have your patent fights in the courts, the traditional courts, I'll say, since I really don't see the PTAB as justifiably having judicial authority, but that's my personal opinion. The patent venue issue is certainly a hot one and ever changing. So John, I think you're taking the lead on the introduction for that.
Yeah, thank you, Denise. Yeah, so as Denise recognized, venue is something that seems like it should be kind of dry, procedural. Remember back to your 1L Civ Pro sort of law. but it is something that we track very closely in patent litigation because it actually has a very substantive impact on cases. What venue you are in is going to affect your time to trial. It's going to affect your likelihood of success on motion practice. It's going to affect the predilections of your jurors, the possibility of large damages exposures. And it's going to impact the entire case strategy that you're facing. So we saw in 2017, the Supreme Court's TC Heartland decision upended the venue laws that district courts have been working with for decades prior to that. And TC Heartland significantly narrowed the prior venue, which was essentially anywhere you were subject to personal jurisdiction. You could be sued for patent infringement. Under TC Heartland, the Supreme Court said you can only be sued for infringement either in your state of incorporation or where you have both committed acts of infringement and had a regular and established place of business in the district. A lot of law on that second prong, but essentially, are you physically present in the district? Do you have some sort of brick and mortar connection to there? And the hope among a lot of the patent defense bar was this would reduce forum shopping and reduce plaintiffs going out to the rocket dockets and the high damages verdict venues. So let's see how that's actually worked out in practice. In 2016, prior to TC Heartland, we had nearly half of all patent litigation filed in Eastern District, Texas. And a large number of those filings were non-practicing entities, patent assertion entities, suing multiple defendants on similar claims of infringement. District of Delaware was the second, in part because it was easy to get jurisdiction there, given place of incorporation considerations, but in part because they have a very seasoned patent bench there. They have judges who see routinely on both the pharmaceutical side and the non-pharma side, a lot of very sophisticated patent litigation. So TC Heartland comes out, and for a few years, we see Eastern District, Texas drop pretty significantly. And we see Delaware come into the fore as the leading venue, and with Northern District, California also up there as a fairly popular venue for patent filing. But within just the last year or so, we have now seen Western District of Texas really explode as a new patent venue. It is easier to get proper venue over patent defendants in Western District of Texas than it is Eastern District, because there are simply more physical businesses there. So you can meet that second part of the TC Heartland test more easily in Western District. It's going to be a case of new boss, same as the old boss with Eastern Western District, very possibly. And Janet is going to give us some updates and some detail on what defendants have done in their attempts to get out of Western District of Texas as a venue.
Yeah, so if we go to the next slide, we just wanted to highlight, we had 3 non-presidential the federal circuit in this past year. And then this new hot area of Western Texas as the hot patent venue. So the first one is a July 2020 decision from the Federal Circuit on a writ of mandamus of Judge Albright in Western District of Texas. So this was a review of his denial of a transfer order. The defendant wanted to transfer to Northern District of California and claimed it was more convenient in that forum over Western District of Texas. So relevant facts here are that both parties had no ties to Texas. The plaintiff was a Delaware company, and then Adobe was headquartered in San Jose, California. The standard that the Federal Circuit looked at was whether the denial was an abuse of discretion, so a high bar. And then looking at Judge Albright's decision, the Federal Circuit found that Judge Albright had given improper weight to the fact that he could see the trial through quicker than Northern District of California over the convenience factors that are traditionally looked at for a transfer motion. So the location of the witnesses, the location of discovery, the ease of witnesses to be compelled into court. Those are all traditional transfer factors that are looked at. There's also public interest factors regarding the speed of time to trial. And the Federal Circuit found that Judge Albright had erred in giving that weight over the convenience of the parties and other traditional transfer factors. So this was the first time the Federal Circuit had overturned Judge Albright, one of his transfer orders, since he was confirmed in 2018. And this was the first transfer actually out of Waco since he was confirmed. So if we go to the next slide, we have another case. This is Henri S.K. Heinings. This was earlier this year, February 2021. Now the Federal Circuit is looking at how long Judge Albright is keeping transfer orders on his docket before ruling on them. So in this case, the defendant wanted to transfer out of Western District over to Central District of California. The timing is important here. So the case was brought in March 2020. The defendant moved to transfer in May, and the briefing was fully briefed by the end of May. Meanwhile, Judge Albright has a very, like Judge Gilstrap, has a very quick and orderly scheduling order that's the same for all of his patent cases. The case was set for schedule with Markman scheduled for March of 2021, and the case forged ahead on the merits despite this pending motion to transfer. So S.K. Heinings, the defendant, moved to stay in December 2020. Judge Albright denied that motion, and as soon as S.K. Heinings filed a mandamus petition to the Federal Circuit, Judge Albright set a hearing for the transfer order. So he got the hint pretty quickly that he needed to move on this motion. So the standard applied by the Federal Circuit was an arbitrary refusal to act on the defendant's request here to transfer. And it found that Judge Albright had let this motion sit for too long. They found it was an egregious delay and a blatant disregard for precedent. So some pretty strongly the Federal Circuit here. Because we kicked this case to another district early on, just a couple months after the case was filed, they found it should have been priority to have the motion heard and decided before forging ahead to the merits of the case. So because Judge Albright took some action quickly after the mandamus was filed, they didn't actually order anything on the merits of the motion. They instead just stayed all merits proceedings until the court could decide the motion. If we go to the next slide, this is the third case. And again, this is Judge Albright. This is In Re TracFone Wireless. And here, very similar facts to the prior case, S.K. Heinings. Similar timeline where the motion to transfer sat on his docket for 8 months. And the difference between this case and the prior case is that Judge Albright had taken no action after the defendant moved for mandamus and actually went ahead with Markman and had a claim construction order. So you can see here the Federal Circuit finds this strikingly similar to the last case because it was nearly identical case timelines for the transfer motion sitting on his docket. And the Federal Circuit said, here we're going to actually grant mandamus, which is a very high bar for relief, and said it ordered Judge Albright to rule on the motion within 30 days of the issuance of the mandamus order. So during that time, all proceedings on the merits were stayed until further notice. And the Federal Circuit went as far as to say, when deciding the merits of the transfer motion, you must not take into consideration the fact that you've now become familiar with the underlying litigation by way of you sitting on the transfer motion. So 3 decisions directed to Judge Albright. He's becoming very prolific here on his patent docket, but also the Federal Circuit is taking notice on that are letting issues linger and letting him keep cases on within his district. Based from the venue issues of recent days, after TC Heartland, it's going to be harder for plaintiffs to form shop with domestic defendants. As John mentioned, the standard is now higher. You must either be incorporated or have committed acts of infringement and have a regular and established place of business within that district. For foreign defendants, it's still fair game. TC Heartland had no impact because the patent venue statutes don't apply to them. So if you're a defendant and you're hailed into court in one of these patent venues, Eastern District or Western District of Texas, these mandamus orders are going to be helpful in helping you combat some of the practices that judges are using to hang on to their cases. So now we have orders from the Federal Circuit saying that courts shouldn't give undue weight to the fact that these venues can get to trial quicker on the merits. The convenience of the parties and witnesses is going to take precedence over that. And again, if your transfer motion is sitting on the docket for too long, now you have two very recent orders from the Federal Circuit saying that it's improper. And this means if you're a defendant, getting your transfer motion and motions to stay on file quicker, and if needed, moving from mandamus, which seems like an extraordinary request for relief, but you can see that the Federal Circuit is not opposed to granting that relief where it finds it's necessary.
Thanks, Janet. This is really interesting, and I think that all the different hot topics together, whether it's the debate on 101 and patent eligible subject matter, the PTAB, how it operates and its authority, or venue, and how defendants can protect themselves, and how plaintiffs can control or try to control venue and choose venue for their particular outcome, reflect a bit of a split within the innovative industries. So something that if you practice in this area, or if you are employed at a company that's an innovative company, you're probably acutely aware of, and that is that the high-tech industry and the biopharmaceutical industry are sometimes at odds on these issues. They've been a bit split because, as you've seen from the venue discussion that Janet just prepared, the non-practicing entities are typically the plaintiffs who have selected one of these Texas districts to try to fast track their cases with a higher than average expectation of success, where practicing entities that have patents that read on to products that are being, sorry, I see my connection's unstable, so if you can't hear me, I apologize. So the innovative industry, the high-tech innovative industry, is not relying on patents in quite the same way in these instances that, say, the biopharmaceutical industry does. So, fortunately, we have a little less, meaning the biopharmaceutical industry, have a little less activity in Texas and have a little more control over our patent cases, the venue of our patent cases. But it's nice to see that the Western District, the Federal Circuit, is pinning the Western District of Texas down a little more quickly than they did in the case of the Eastern District. So our next section, I think, well, I'm not sure we're going to have time, but if you want to, John, if you want to run through damages.
I think I will give a 2-minute preview of
Sure.
what emerging damages issue is, and then we can leave a couple minutes for questions at the end. So one example of why damages matter, we are now firmly in the era of the mega verdict. Used to be maybe 8 or 10 years ago, a verdict in the billions was truly exceptional. We now have a number, the billions and the 2 billions. And if you'll notice the VLSI verdict from just a few weeks ago, Western District, Texas. So to preview an issue in damages that I think is emerging as a split amongst district courts and a potential split amongst federal circuit panels that maybe is not at the level of a full boil like Section 101 is right now, but is certainly at least starting to simmer, is the question of when you are dealing with a reasonable royalty, which, to give you the framework for that, is the amount that in a hypothetical negotiation between the plaintiff and the defendant, what they would have agreed to for a royalty for the defendant to be able to use the patented technology. When you are doing that hypothetical negotiation, how far down into the defendant's revenue do you have to drill to get to what the contribution of the patented technology is as compared to all the other innovations that are in that product. This is, kind of one of the classic smartphone or computer examples that, any given electronic device has thousands or tens of thousands of patents worth of technology in it. And how do you find the particular point of that technology that is the footprint of the asserted patent? And we have a divergence in approaches, I think, on Federal Circuit panels here. That we have some guidance from this case, Finjan, and some other cases like Finjan, where if you get to the smallest point of revenue that the defendant is selling, and there are still other types of technology in there, you have to keep going, and you have to more narrowly than that, what is the value of the patent. But then you have other cases coming out like Biorad, where essentially the damages expert can say, I have done an apportionment analysis, and some courts simply credit that without looking a lot further. So what does this mean practically speaking for defendants that are involved in litigation, plaintiffs that are considering litigation? Think about damages from the start. Be having active discussions with your outside counsel about damages and about what you think the damages in the case ought to be or might be, or in a worst case scenario for defendants, what they could be. Listen to your internal fact experts, your salespeople and your business people, because they will be the people giving testimony under oath about your product and the technology in your product. So you want to get an early understanding in the case about what they think the technological contributions are. And make sure you know your judge and your jury as well. Some judges are very Daubert happy, very happy to exclude expert witnesses they think are straying from a narrow apportionment path, and others are kind of happy to let everything go to trial and let juries sort out the damages factors. So takeaway for that basically is think about damages early and often. So with that said, we will open up the floor for a minute or two. I see we're at 12, but we can take any questions that folks have.
I'll ask you a quick question. John, in the damages cases that you just highlighted, were any of those triple damages as a result of willful infringement findings, or were they all representative of just kind of standard infringement?
I believe all of those were based on jury verdict. Some of the earlier ones may have reflected troubling or enhancement from the judge. Okay. But yeah, those are all more or less the actual damages assessed. Okay, unless I can't see chat with my screen share open, but unless there are questions in chat, I will thank everybody very much for your time.
And Josie, I'm not sure, I know that there's a networking half hour next. Audrey or Josie, perhaps you could tell us how that works.
If you guys do want to stay, we can have some networking afterwards. It's up to you guys. I can divide you into breakout rooms.
Well, I would say, let's see. My inclination is that unless a number of people want to indicate somehow in the chat or something that they would like to do that, I'm cognizant of people's time. I'm sure Janet and John and I are happy to stick around for a little bit if people would like to, but otherwise we'll let you get back to work.
Thank you, everyone.
Yeah, great. Thank you. Thanks so much, John and Janet. Really appreciate it.
Take care, everybody. Thank you.
Thanks.
Bye-bye.
Bye.